02. We've still got some people dialing in, but we probably should go ahead and get started. Are you guys all ready to get going?
I'm ready.
Okay, sure.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. I'm pleased to welcome you to the next webinar in our ABI-Live series. Today's webinar, which is hosted by ABI's Real Estate Committee, covers recent trends in lease rejection. Our panel of experts will review trends in lease rejection on a national level from both the legal and financial advisory perspectives and provide an understanding of how bankruptcies affecting retail, office commercial, hotel, healthcare, and manufacturing leases have changed the lease rejection landscape. Before I introduce you to the panel of speakers today, though, I'd like to address a couple of housekeeping matters. If you need CLE, please make sure you are recording the CLE codes that will appear on your screen throughout the program. Also, during the webinar, if you have questions for the panelists, please type them in the GoToWebinar conversation box on the right of your screen. These questions will be sent directly to our panelists. I now have the honor of introducing our panel of speakers. George Angelich is a partner in Arent Fox's Financial Restructuring and Bankruptcy Group in New York, where he focuses on corporate reorganization and bankruptcy matters. George represents committees of unsecured creditors, secured creditors, indenture trustees, bondholder, and noteholder groups, and other entities in bankruptcy reorganization and liquidation proceedings. Prior to joining Arent Fox, George served as a law clerk to the Honorable Arthur Gonzalez of the Southern District of New York and the Honorable Cecilia Morris, also of the Southern District of New York. Our next panelist is Rob Vanderbeek. He is a managing director with Golden Associates in New York and has more than 20 years of restructuring advisory, interim management, and litigation support experience across a broad range of industries. Rob has significant experience with restructurings relating to financially and operationally distressed businesses in the retail, restaurant, and hospitality spaces. Our final panelist is Greg Werkheiser. He is a partner with the Business Reorganization and Restructuring Group of Morris, Nichols, Arsht & Tunnell in Wilmington, Delaware, where for the last 20 years he has represented distressed companies, fiduciaries, secured and unsecured lenders, trade creditors, and acquirers in financial restructurings, bankruptcy proceedings, loan workouts, commercial disputes, cross-border cases, and much more. Greg has worked with clients from such diverse industries as steel, oil and gas, real estate, construction, pharmaceuticals, healthcare, fast casual dining, professional sports, and many more. Welcome to all of our panelists, and thank you to each of you for being with us today. Greg, I'm going to hand the program off to you.
Okay, thank you, Amy. This is Greg Werkheiser, and thank you to everyone for taking time out of your schedule to join us today. We're happy to have the opportunity to talk to you about this subject, which I think is something that anyone in business bankruptcy, comes across pretty routinely. My job here is just to give you all a brief overview before I turn it over to my colleagues. And of course, I think we all understand how critical the primary provisions of the bankruptcy code relating to lease rejection and lease termination damages claims are to many of our business bankruptcy situations and even out of court restructuring situations. And I think, we've all likely, have seen how the landscape has changed over the last decade plus since BAP-CEPA was enacted, and there's been a good deal of hand-wringing, in many cases with good cause, over some of the limitations in BAP-CEPA that were perceived as harmful to the ability of especially retail to successfully reorganize in Chapter 11. I had the privilege of being down at the Georgetown Views from the Bench conference at the beginning of the week, and for anyone who's interested, the panelists there did a pretty comprehensive review of retail and a discussion of how the BAP-CEPA amendments have affected the retail restructuring and reorganization environment. And I think that the consensus view, which I would probably share, is that in many cases in retail, especially and fast casual dining, the 363 going concern sale has become the new reorganization. That said, I think there has been some change in that trend recently, and we've seen a number of cases where where there's been an opportunity to do a fair amount of pre-planning. The cases have come into bankruptcy either pre-negotiated or in some cases pre-packaged. And examples that come to mind are Gymboree, Payless Shoes, Route 21, Perfumania was a recent actual prepackaged case in Delaware. Just the other day, for example, we had a filing by the parent company that operates the Romano's Macaroni Grill restaurant chain here in Delaware, where I practice, and their discussion of their situation, I think, is sort of telling in terms of the importance of the lease rejection provisions to the bankruptcy code as a tool to help restructure these types of companies. The press release that company issued on the day it filed indicated that the filings are part of a consensual plan by the company's owners and its lenders to shed the company of legacy liabilities that have been accumulated through multiple ownership changes. And in that case, I think the most recent one was just within the last 2 years, and have burdened the company for several years. The company strived to reach out to all of the strive to reach an out-of-court settlement with all of the landlords of closed units to optimize the company's operations. However, a global settlement was not reached, and the decision was made to file for Chapter 11 as a more prudent course of action. And to this end, on the same day of the filing, the company filed a motion to reject 35 store locations that had been, according to the company's papers, previously vacated, and as which they think they've actually terminated the leases pre-petition, but they're still seeking a rejection relief, and are seeking that relief effective as of the petition date. And as we'll discuss as we move forward with today's presentation, things like this are often critical to the ability to pursue reorganizations, to manage cash flow, and generally maximize value. If on slide 3 of your materials, you'll see a quick overview of how we've attempted to organize today's material, and I won't bore you with repeating what's already in your materials, but suffice it to say, there is probably so much that we could talk about that we're not going to cover everything. I do, however, believe that we've put together a program for you that will focus on the materials that are most relevant, especially to business bankruptcy practices and restructurings, and where there's been the most recent action in terms of financial, business, and case law developments. With that, I'll turn this over to my colleagues, and we can get started with the substantive presentation. Thank you.
All right. So, all right, let's skip ahead a few slides to, I think, what is slide 7 in your packet. It discusses 365D4. As many of you will recall, in 2005, one of the key features of BAP-CEPA was to rebalance the playing field. Commercial landlords had been dealing with, for many years at that point, a situation where their lessors in Chapter 11 would simply be confronted with a request they would be confronted with the request to extend time by their lessor debtors. And, they could get 60-day extensions and so on. These extensions would go on in perpetuity. And these debtors had certainly the upper hand in these requests for extensions. Landlords finally were able to prevail on Congress, and in the 2005 amendments began to really sort of limit here how much time debtors could really obtain under the code. So the structure of 365d4 now provides for assumption or rejection by the earlier of 120 days after the order for relief or the date of the entry of an order confirming a plan. 365d4 goes on to provide an additional 90-day extension, but that's it. So you have a grand total of 210 days from the petition date to assume or reject. And if you haven't assumed by that point, in effect, you're going to be deemed to have rejected. Now, there's some dispute, there's some case law, going both ways on the question of whether or not the rejection is automatic on day 211. But for purposes of our discussion, what I want to focus on is a couple of key points. First, when we're dealing with this extension of time, what currency does the debtor have to go beyond 210 days? And second, what constitutes cause to extend the 120-day period in the first place? And so with respect to cause to extend the 120-day period, just turn to the next slide. The courts have fashioned a number of different standards here. And what we've seen is an evolution of a number of factors. And they all really sort of revolve around this question of, does the debtor have money and sufficient cash to pay its rent? Courts have looked for, whether the lease is significant to the debtor's business and the plan, whether rejection will produce a windfall to the landlord. Has the debtor had sufficient time to appraise its financial situation, potential value of the lease? Other factors are complexity of the case, the need for a judicial determination about whether a lease exists, and so on. So there are a number of factors out there, and I think at the bottom of all of these factors is really this broader question of how important is this lease to the debtor's reorganization? Can the debtor pay its rent? What are its true prospects for reorganization? And what is the debtor's realistic objectives in the case? And I think you can get your extension on day 121, and you can go beyond that 120-day period and get your additional 90 days. But remember that the whole purpose behind this amendment was really to give landlords more leverage. And I think you have to go back to, really what's occurring pre-petition to understand that. What the real goal of this amendment was to get landlords and debtors talking with the lender pre-petition to try to come up with a solution. And I think what's happened as time has gone on is that those conversations are becoming fewer and fewer pre-petition, such that it's basically locking in a dynamic where when a retailer files nowadays, it's almost predestined in a sense to have to tee up a GOB or a liquidation. Now, that's not true in all cases. We've certainly seen a few instances recently of successful reorganizations of some retailers. But the overwhelming majority of retailers are confronted with this dynamic where they're incapable or are not able, frankly, to have these kind of conversations with their landlords and lenders pre-petition. There is a dive into bankruptcy, and then there really is no game plan beyond simply a straight-up liquidation. And going beyond the 210-day extension period is becoming increasingly more difficult. And so what currency does a a honest debtor have to try to get beyond 210 days? Well, we have a few examples on this slide that you see right now, slide 8, where you'll see in Hancock Fabrics, Linens and Things, and Movie Gallery that debtors have been coming up with some solutions here. They've been able to compromise preference claims, for example, and give other forms of consideration to get that additional time. So BAPSIPA has effectuated important change under 365D4, but it in some ways has almost preordained many retailers to head down the liquidation path. Would additional time benefit those retail debtors? Quite possibly. To usually at the expense of landlords, which obviously BAPSIPA was designed to correct. So the 210 additional day, that extension beyond 210 days, you'll see there are ways to accomplish that. They are relatively rare, and frankly, it is a statutory hard stop, so you have to get consent of the landlords. What we've also seen recently in for example, BCBG, where you have the ability, and this is not uncommon, it's not just BCBG, there have been other cases that have provided this, that in the plan, there's additional time to make that determination concerning rejection. So you can actually go beyond plan confirmation, and 365D4A2 talks about you have to make that rejection assumption determination by the date of the plan confirmation. That, however, is frankly somewhat flexible if you can get it in a plan and you can get additional time for that decision to assume or reject. So that's 365D4. Greg?
Thank you, George. I think we're now at slide 10 of your materials, and we're going to talk briefly, or excuse me, slide 9 of your materials. We're going to talk briefly about the standards for lease rejection, and I think most of us are familiar with the business judgment standard as a concept, and that is by far the prevailing standard here. Step back for a second and just remind everyone that when we talk about the business judgment standard in the context of bankruptcy, it is a slightly different concept of business judgment than you all probably may be familiar with under corporate law, particularly Delaware corporate law, where it is, described as a standard of review that in substance essentially says that as long as you're not conflicted and you've exercised the requisite care to become informed and haven't acted in bad faith, that no judge is going to second guess a board's decision making. I think most bankruptcy judges would say they don't go that far in applying business judgment in the bankruptcy setting. At the end of the day, the judge still has to approve it, and while that may involve a substantial degree of deference, it's not going to be, I think, in the view of most bankruptcy judges, completely hands off, and you see that to some extent in the case law. So even in the courts that apply a business judgment standard, they do allow themselves a safety valve, talk about bad faith, whim, or caprice as situations where it won't be applied. Factual settings where there is no appreciable apparent benefit to the debtor's estate, but significant damage to another party, are the situations where you might see a court deny a lease rejection, even under the business judgment standard. And then I would just remind everyone that there is still a handful of courts that adhere to a minority view, which more directly takes into account the extent of damage that lease rejection will cause to non-debtor parties. There are a couple of cases cited in our materials from Northern District of Georgia and Western District of Washington as two examples. So you can't certainly assume that that there won't ever be departures from that. I think I have the next topic as well, which picks up on slide 12 of our materials. This goes to the issue of what, how do you define what is subject to an assumption or rejection decision? Of course, this involves Latin that we're all somewhat familiar with, cum honore, in more common usage. The concept is severability, we've cited some cases in our materials. Perhaps most notably, Buffet Holdings as an example of one situation where this concept that comes into play. I think, in terms of how does this practically impact your practice and your clients, we see this coming into play most often in situations where a company has done, as occurred in Buffet, a sale leaseback transaction, and of course, by the time in a transaction like that, by the time you arrive in bankruptcy, it's too late really to do anything about that. So I think the takeaway I would suggest there is, the planning has to be done well ahead of time. Your transactional folks need to be focused on, depending on your perspective, maintaining the sale leaseback arrangement as a unitary arrangement if you're coming at this from the landlord perspective, or maintaining some level of flexibility to treat different components of a sale leaseback arrangement separately, from the company's perspective or its lender's perspective. But again, this is all planning that has to be done, well ahead of a company finding itself in financial distress, and is something that you want your folks to be focused on. Second scenario that comes into play here is occasionally you'll find amendments to leases, and we cite one case in our materials, In-Ray Contract Research Solutions out of Delaware, where over the lifetime of the lease there were amendments, and those amendments expanded the space being let to the tenant, the debtor tenant, and while it was in the same office park, the building was actually a discrete structure on the premises, and the litigation in bankruptcy that followed revolved around whether that amendment itself could be deemed as a severable lease, and in the context of this case, at least, the hallmarks of that were not there. While it added additional premises, it still relied on many of the same lease provisions that governed the other lease portions, and there was no indication on the face of the documents that there was an intention to treat that as a severable agreement. The third scenario where this concept of severability often comes into play has to do with leases that have baked into them purchase options, rights of first refusal, and so on. And again, we cite to CB Holdings in our materials as one example, where the value locked into this leasehold arrangement was a liquor license that had been used to operate this restaurant, and could be transferred for significant value. The landlord had negotiated for a right of first refusal for that in the lease document, And the issue came up when the debtor sought to reject the lease, whether that right of first refusal was a severable sub-agreement or whether it was part and parcel of the lease. And I believe that was the Judge Walrath decision out of Delaware. She ultimately agreed that there had been no intent to separate that from the actual lease itself. So again, I think we look at these issues and we deal with them from a motion practice and a litigation perspective once we get into a filing. But the takeaway, even in these other contexts, is that these disputes are usually won or lost, well before the company slips into bankruptcy. It's going to be being attentive to these issues in your documentation and making sure that the record has been created well ahead of time for whatever agenda your client has. Let's see. I think I'm still up on the next topic, so we should be at slide number 14 by now. And this is a topic that I'm sure we've encountered many times. It deals with the retroactivity of lease rejection. And the starting point, of course, in bankruptcy motion practice in most cases is that whatever relief you get is typically not effective until the bankruptcy court enters its order, and that order becomes effective by its terms. Because of the dynamic that we have, especially as it relates to commercial real estate leases in bankruptcy, the requirement under Section 365D3, as George will cover with you, to pay those obligations currently, and the approaches that many courts have developed with the billing date versus alternative approaches to interpreting that. This issue of when does a lease rejection become effective is critical for many debtors, and essential to their ability to manage cash flow. And what we've seen, and again, as I mentioned at the outset, most recently in the Macaroni Grohl case filed just yesterday, is that debtors are attempting to avail themselves of the opportunity to make their rejections effective retroactively, usually to the case of filing of the motion, but sometimes in extreme cases to even a date prior to that. So sometimes the motion will not have been filed until a week or 2 weeks after the petition is filed, and they'll still ask for relief retroactive to the petition date. And most courts, confronted with these types of requests, have indicated, as an initial question, that yes, they do believe they have the authority under the code to grant equitable relief, which means that there is, under appropriate circumstances, the ability to be retroactive to at least the filing date, and we've cited a number of those cases on slide 15 in your materials. And you've seen courts attempt to distill, various equitable factors that they view as important to evaluating these types of requests. And one set of factors that we discussed in our materials on slide 16, that have been, to one degree or another, sort of the prevailing practice in Delaware for many years, are the so-called NAMCO side retainment factors that Judge Walsh announced back in 1998. And the concepts are ones you would expect to see. Lease premises were previously surrendered to the landlord. The surrender was accompanied by the debtor's unequivocal statement that it was abandoning any interest in the lease. Third, that there was no undue delay in filing the motion. Fourth, that if there's a committee, there's indication that the committee is on board with the motion. I would editorialize there that in practical application, would also, try to make the representation that the debtor has the support of its, secured lender and DIP lender in the papers to bolster the record from the debtor standpoint. And then I think something that was part of what Judge Walsh articulated as part of the standards when he announced them, but my experience, I see not done as faithfully as perhaps Judge Walsh might have wanted back in the day, is that the debtor makes a clear statement that it's waiving any right to change its mind later on. And obviously, we all know that things tend to move very fast in these situations. These motions are usually filed at the beginning of the case when the case is quite chaotic, oftentimes, and so the information is not perfect. So there's an understandable reluctance to make that sort of representation. And occasionally, it does come back to bite people. Those that have been doing this for a while might remember the Fleming case back in the early 2000s as an example of that, where the case was in such constant flux, and it was a huge, very difficult case, that there were a number of attempts by the debtor to seek retroactive relief on lease and contract rejections that got halfway through when the debtor realized, no, in fact, I really still need these, tried to withdraw them. In most cases, if memory serves, they were able to, but the judge became increasingly frustrated with the indecisiveness of the debtor, and it actually became an issue later on in the case when professionals were seeking to get paid. So, that is something, while not always articulated in the papers, that is still critical to implementing this. The other area where you see some issues arise when people are looking for retroactive lease rejection has to do with what is, actual abandonment of the premises. And, oftentimes, well, not often, but occasionally you'll see these motions filed where a debtor is representing that, yes, we've removed everything from the premises, and, lo and behold, the debtor has left a bunch of it, it's equipment there that it's not prepared to have outright abandoned, or, or there's items belonging to third parties, such as, shelving that maybe is the subject of, secured financing for a third party, or other equipment that is leased or financed through a third party. And so the debtor has not done what arguably this standard contemplates and completely address what has become of that property. And so when those issues arise, landlords are often apt to show up and challenge the retroactive relief, and when if the record supports that, they're apt to be successful in many cases. The other context where we see this getting messy, in my experience as well, is where there's a subtenant on the premises, and while the case law is somewhat limited in this area, the prevailing view at this point seems to be that so long as it is clear that the debtor has not obtained any current benefit from having a subtenant there, hasn't continued to collect rent, hasn't done anything to induce the subtenant to stay on the premises and believe that it can stay there, that the effect of the debtor's rejection of the overlease is to extinguish the sublease, and that will be sufficient for tendering back the premises to the landlord. So my experience, at least, has been that in most cases, the court will agree with that result. But not always, and we do cite the Chi-Chi's decision out of Delaware in our papers as one example where the court had reservations about retroactive rejection where subtenants were remaining on the premises. I think
Yep.
that about covers. So I'm going to tender this back to George for our next topic.
All right, 365D3. If you could go to the next slide, please. And next slide. So if you go to slide 19, please. So you represent your counsel to a company that's about to file for bankruptcy. Well, let's call them Glitzy Fad Retailer. So you haven't had any discussions with the landlords or your lenders about how you're going to deal with post-petition rent. You know you're up against the 365D4 timelines, and yet you have a cash crisis, right? You don't have a realistic game plan for reorganization. It's looking like a liquidation. So you go to the Glitzy Fad Retailer board and you explain 365D3. D3 was effectively enacted in 1984 and was functionally designed to just ameliorate some of the financial burden on the commercial landlords. And yet, what we've seen under 365D3 is that it's, some people take the view that it's 60 days of free rent. And in reality, it really sort of is, because the duty, the burden for timely performance is on the debtor as lessee, and it is obligated to perform all of its obligations, but those obligations terminate on rejection. But the code section doesn't contain any remedy for failure to comply with its obligations. So what effectively happened? So let's first talk about what the world looked like before 1984. So if you go to the next slide. Prior to 1984, if you go to slide 20, please. You had basically you were required to. I think you went too far. There you go. And prior to 1984, landlords effectively had to make a motion under 503, and they needed to come forward to the court and ask for an administrative claim for actual necessary costs for preserving the estate. Just as a footnote to that point, the Third Circuit has sort of gone back to that in certain limited circumstances that we'll talk about in a moment in connection with stub rent. And then if you're successful making your admin claim motion, you were able to then basically get your rent paid going forward. D3 was designed to remedy this problem. Because it puts the onus on the debtor trustee to basically perform. Can you go to slide 21, please? And the question becomes, if you're able to prevail on your D3 claim, when do you have to pay that claim? And courts take a number of different approaches to when you have to pay that claim. Some courts say you don't have to pay until you have sufficient cash to pay all administrative claims. Other courts take the view that it doesn't matter. You have to pay these D3 claims, and they almost are on par with sort of like a super priority claim. You got to pay them and pay them now. And yet there's a third approach, which is sort of a midway between the other two, which is you pay them, you pay those D3 claims, but the landlords are subject to disgorgement. So if it turns out that there's not enough money to pay all admin claims, then there has to be a disgorgement and then a true up for all admins. So there's some risk to the landlords. Next slide, please. So, as you all know, this issue really comes up in the context of this concept of stub rent. And most everybody understands what stub rent is, but for purposes of this presentation, let's use the operative definition. The stub rent is the amount of rent corresponding to the period of occupancy between the petition date and the first post-petition rental payment due date. And that effectively requires, right, that if you have rent that's due after the petition date, well, that sort of makes sense. Okay, so that's an admin claim. But what if the rent due date straddles the petition date? And I'll give you an example of that in a moment. So there have been cases that come out and there's this split, right? There's proration approach and there's billing date approach. So if you could go to the next slide. When we talk about stub rent, the proration approach, next slide, thank you. Actually, could you go to the prior slide? There you go. So proration. Let's use a hypothetical here. In the Glitzy Fad retailer scenario, rent was due on September 1st. The petition date is September 5th, and your rent is due again on October 1st. The question is twofold, right? Well, is the rent that was due on September 1 and that was not paid, is that entire amount an unsecured claim? Or are you able to prorate the amount of rent that was due across the balance of the month so that you can get an admin claim for the period of September 5th through October 1? So that's the issue that the courts have been struggling with for the last several years. And courts have adopted, and I would say the majority of courts have adopted the proration approach. The 7th, 9th, and 10th circuits have clearly stated that proration is the correct approach. And in fact, you'll recall the Commission to Study Reform of Chapter 11 has also recommended the adoption of the proration method. The case that I think really stands out is the one that the 7th Circuit ruled on in Handy Andy, and the court basically ruled that the debtor wanted to continue occupancy of the lease property until it rejected the lease. To get this benefit, it had to pay the full rent under the lease for every day that it continued to occupy the property. And by the way, the court goes on, the debtor's tax obligations to the landlord related entirely to an earlier period and is thus no different from its debts to trade creditors for supplies that it bought but never paid for. So the notion of paying for your rent on a proration approach, a proration method, makes a lot of sense. So if you're occupying this premises on September 2nd, on September 6th, a day after the petition date, why should that be sort of lumped in with a pre-petition claim merely because rent was due on September 1? You're occupying the premises on September 6th. You should, under the proration method, be obligated to pay that as an admin claim. So the proration method takes that view. Okay, next slide. Now, there are some courts that take the billing date approach. As many of you are familiar, the 3rd, 6th, and 8th circuits have adopted the billing date approach. And that's sort of the so sad, too bad approach where, okay, well, the rent was due on September 1, it wasn't paid. Well, that entire first month is just a general unsecured claim. The Montgomery Ward decision in the 3rd Circuit, which was issued in 2001, was the first articulation or clear articulation by the circuit on this issue. And the majority decision concluded that the language itself of D3 clearly requires that the billing date interpretation be followed and that there is no statutory support for proration. The court went on to say, in the context of a lease contract, quote, it seems to us that the most straightforward understanding of an obligation is something that one is legally required to perform under the terms of the lease, and that such an obligation arises when one becomes legally obligated to perform. And the court went on to say that there's no ambiguity in D4, and therefore the court concluded that there was no justification to looking into the legislative history for interpretive assistance. And that's relevant because Judge Gropper took a slightly different view in the Stone Barn Manhattan case, which is the next slide. In Stone Barn, Manhattan, which is also known as Stephen Barry's, Judge Gropper firmly endorsed the proration approach. He also noted that the billing approach, can lead to absurd results. So at this point, the Second Circuit hasn't yet ruled, but I think the hope is that we're going to get a clear decision from the circuit at some point. Next slide. In the Eastern District of Virginia, where we've seen Toys R Us file, you'll recall the Circuit City decision. The bankruptcy judge there basically took a very interesting approach. He said proration applies, but immediate payment isn't required. Okay, and his rationale for that was doing otherwise could effectively elevate a stub rent claim to some sort of super priority status, which was something he couldn't countenance. And so that really creates an interesting result. So you've got this order that says proration applies, but immediate payment isn't required. So what good is that order for you anyway? So you have to do what? You have to wait until confirmation or assumption. So you're still waiting until the end of the case to get paid. If you're dealing with confirmation or assumption, you got to deal with cure and payment at the end of the case. So in some regards, you get some protection if there's a rejection of your lease because you're able to capture more days as an admin claim using the proration method. So for creditors in Circuit City, landlords in Circuit City, you're kind of waiting for your lease to be assumed. You're waiting for the payment, and frankly, you get protections if your lease is rejected. But again, you're still waiting till the end of the case, and that brings us to the next slide, which is the Goody's Family Clothing decision, and this is the standard really in the Third Circuit. Unfortunately, in the Third Circuit, you have to deal with the billing date, but you can still assert a 503b1 claim. As I mentioned before, prior to 1984, you had to prove you had the right to a 503b1 claim if you were a landlord. What Goody's did was basically say, okay, fine. You're going to have to live with billing date because that's what we interpret the statute to require. But you can still apply for a 503b1 claim if you're able to prove that, the 20 days or so in September that I gave you in my original hypothetical from September 5 to October 1, those 25 days or so, if you can establish that you should have a 503b1 claim there, then you'll be protected. You'll have an admin claim. So what will go into that? Well, you're going to have to prove that there was some actual necessary expense here for the estate, that it provided some form of benefit to the estate. How do you show that? Well, generally speaking, it'll be if you can conceive of a situation where there's a going out of business sale, and that going out of business sale is being, frankly, run out of your premises as a landlord, right? And they're running this going out of business sale, and it's resulting in value for the estate, and that value translates into a distribution of creditors. Hey, you've contributed to that overall undertaking. You should be entitled to a 503b1 claim for those 25 or so days that you would otherwise be unentitled to receive anything under the billing date approach. So the Third Circuit has put down a rule that I think makes a fair amount of sense in light of the statutory language. And that's basically it for stub rent.
Thanks, George. This is Rob Vanderbeek, Golden Associates, and I want to thank everyone for joining us today. I'm going to talk about Section 502b6, which puts a cap on damages, and it's really an important concept to understand, regardless if you're on the debtor or the creditor side. I've worked over my career as a financial advisor on 6 retailers, and all have been impacted by this damages cap. So I'm going to start slide 29. start with the overview. When a landlord files a timely proof of claim after a lease rejection, there are two components to that. One is going to be the claim for unpaid rent at petition date, and the other, which we're going to focus on more, is the claim for future rent, which is going to be capped by 502b6. And this cap basically is a claim for damages from lease termination. Now, the cap on the landlord's rejection damages is done at the rent reserved for the greater of 1 year or 15% of the remaining term of the lease, not to exceed 3 years. And there's been a significant amount of debate over the years in terms of whether or not that remaining term of the lease should be looked at in basically a rent or a time approach. And the rent approach is looking at the amount of rent due, while the time approach is really focusing on the remaining term of the lease. And case law has supported both of these methodologies. More recently, I think the time method has been adopted, and I'm really referring more specifically there to Delaware. Actually, Southern District of New York historically has followed the rent approach. The way that you determine a claim is, first you basically are going to look at the lease termination damages, and if damages flow from the lease termination, then it's going to be subject to the 15% cap. Once you've made that determination, then you have to also see if it falls under what's called rent reserve, which was kind of in the definition that I read earlier. And rent reserved is actually part of a test that the Ninth Circuit in In re McSheridan came up with, and is basically whether or not a charge must be part of rent or part of the tenant obligation, or the charge is related to the value of the property, or it's considered rent because it would be either fixed, regular, or periodic in nature, and then it would fall under rent reserved. The other concept, total rent, is in essence looking at a base rent as well as other rent amounts. These additional rents, for instance, could be property tax, could be insurance, as examples. The statute basically, as I mentioned earlier, it says not to exceed 3 years. So in essence, 15% of a 20-year lease, really anything over 20 years, you're going to get knocked down to kind of the 3-year damage cap. And then next, it's important to establish a rent cap date, and this is going to be the earlier of the date of the filing of the petition, or the date in which either the lessor repossessed or the lessee surrendered leased property. Let's go on to the next slide. So I wanted to address a case study here that I think highlights the debate that I had mentioned earlier. It's a case that was filed in the District of Delaware back in 2001 called Filene's Basement. And just to give you a quick background on it, the landlord entered into a retail lease at an original term of about 20 years with several 10-year renewal options on it. And the tenant had an obligation to surrender the property in broom clean condition. And Filene's Basement took over this lease from the original company and exercised the option to renew the lease. And then once Filene's Basement filed, there was a rejection of the lease, and the landlord filed a proof of claim that consisted of the unpaid rent as a petition date, as well as the claim on the future capped rent under 502b6. And then in addition, the landlord subsequently filed an amended claim to add damages related to the cost of removing abandoned furniture and fixtures, as well as satisfying a mechanic's lien. that had related to servicing of building elevators that had gone unpaid. And the landlord had asserted that these new claims were not subject to the 502b6 cap. George is going to address these later in some more detail, although I'm going to mention the ruling on them. To the next slide, please. The filings had objected to the landlord claim, in essence saying that it was improperly calculated and that the additional damages should be included. And so in getting to the heart of the time versus rent, these different approaches, which we're going to cover when we get to the next slide, because we have an example of the calculation. I think it's important to note that the time approach has always been favored by debtors and other unsecured creditors, and that's really minimizing the landlord allowed claim and increasing the recovery to the other unsecured creditors, whereas the rent approach has always been favored by the landlords because it's resulting in a larger allowed claim and a higher recovery for the landlord. And just to give you a quick summary of where Judge Kevin Carey came out, he ruled in favor of the debtors, saying that the time approach was the preferred approach and reduced the claims accordingly. Judge Carey also ruled that after applying the In re McSheridan test that I had mentioned earlier, the abandoned property claim for removing the property, those damages were related to lease termination and therefore subject to the cap. But the costs did not qualify as reserved rent because they were not fixed, regular, or periodic, so they were not included in the cap. In terms of the mechanics lien, the claim for the cost of removing the lien existed independently of the lease termination, so it was not subject to the damages cap, and the landlord was able to assert a separate claim. Next page. Okay, this is the actual claims calculation. I think it's a relatively simple and straightforward calculation. The areas where you're going to run into trouble here are more so understanding what qualifies, and oftentimes the landlord will throw in what we call the kitchen sink, and so you need to apply the test to see if it's rent reserved or not. And it's also, I think it's important to note that claims for the unpaid rent are not at all limited by the damages cap. Some people get those confused, but just wanted to be clear about that. And just kind of walk you through the significant differences between the two approaches. The rent approach really takes the total over total rent and additional rent over the remaining life of the lease, and that's going to include property tax, insurance, and it's going to include any kind of escalators over the life of the lease. And the time approach will just include the first 15% of the remaining term of the lease, not to exceed 3 years. So in essence, while you're still at the time, you're including the property tax and other additional rent items. You're only getting the benefit of the escalators for the first 15% of the time remaining, and that's what really tends to lead to the difference. And I think if you look over and walk through the actual calculations themselves, taking the rent approach where you've come up, you basically scheduled out the total rent, including escalators over the lease life, and taking 15% of that, and then comparing that to a calculation done for the time-based approach where you're going to take the time left on the lease and times it by the percent of time allowed under 502b6, and you're going to, in this instance, you're going to calculate 12.75 months, and, in order to come up with the total, you're going to take the 12.75 months, you're going to times it by the total rent, you're going to do a total rent by month schedule, and for the first 12.75 months, that is going to is going to be your number that you times by the statutory 15%. So I think that that should kind of lay it out at a high level in terms of how you would calculate the claim. And I think with that, I will hand it back over to George to focus more on the detail on what is included in the cap.
Sure, thanks, Rob. So under 502b6a, it talks about the rent reserved by such lease. So what does that mean, right? So what are we talking about when we're talking about the rent reserved? What can be included in it? So, for example, if a tenant destroys the leased premises or leaves equipment or waste on the premises, should the landlord have a claim for damages resulting from these actions? Should that claim be capped as part of this rent claim, or should that claim be allowed to sort of stand on its own and be treated as any other claim in bankruptcy? And courts, as you might expect, have sort of gone both ways. So for folks who haven't encountered a 502b6 calculation before, you could be dealing with a situation where the courts in your jurisdiction take a very narrow view, or they take an expansive view of what the cap should include. So let's talk about three types of claims that can arise that have the look and feel of rent, but may actually be a claim that stands on its own. So we'll talk about the damages to premises, attorney's fees, and then there's this sort of subcategory on the side of mechanics liens. So in terms of damage to premises, okay, so the case that sort of came out and started to deal with this question was the decision in McSheridan. So in McSheridan, the Ninth Circuit BAP established a three-part test in talking about the charge must be designated as rent in the lease, or it must at least be related to the value of the property, or it should be properly classified as rent because it is a fixed, regular, or periodic charge. And that decision was in 1995. In 2007, the Ninth Circuit came out with the El Toro Materials decision. And in El Toro, the court concluded that it would cap rent claims but allow uncapped claims for collateral damage. And so that was obviously an important advance of the case law in the Ninth Circuit. So in 2007, you have El Toro holding that a landlord's claim for waste, nuisance, and trespass did not result from the rejection of the lease. Instead, those claims resulted from the damage or waste left on the property. So, as you can see, we have underlined and in italics the test here, assuming all other conditions remain constant, would the landlord have the same claim against the tenant if the tenant were to assume the lease rather than rejecting it? And the court there effectively created this ability for landlords to have a second type of claim. Now, that's an important evolution, right? Then you get to also in 2007 in Delaware, in Re Fomex, which was decided before El Toro and relied on the McSheridan standard. So you have Fomex looking to the El Toro standard and holding that the court allowed damages for unpaid rent and unpaid taxes, plus damages for breach of the repair and maintenance covenant only up to the statutory cap. So Fomex took obviously a different approach. So that's how damage to premises sort of sorts out. If you're in the Ninth Circuit and in the Third Circuit, Now, next slide. What about attorney's fees? Attorney's fees, similar type of split. You'll notice that in the District of Rhode Island, at least there's a decision that precluded the payment of attorney's fees, additional damages. But in the Ninth Circuit, in Ray Kupfer, you're not capped. So I think that this is going to remain a sort of an area where there's yet further evolution to occur, and you're going to sort of have to keep an eye out which jurisdiction you're in to assess whether or not, if you're a landlord, whether you can collect attorney's fees or what your rights are for damages to the premises. Next slide. Final point on 502b6 cap, mechanics liens. You'll see that in Ray Filene's basement, there, the District of Delaware applied the El Toro standard. And we just finished talking about how in Ray Fomex used McSheridan, but here in Filene's, they go back to El Toro. And the court concluded that the mechanics lien exists independent of whether the lease is terminated and not subject to cap. All right, so that's 502b6 and what's included. Next slide.
Great, thanks, George. It's Rob Vanderbeek again. I'll address the high-level issues as it relates to security deposits, guarantees, and letters of credit. A tenant security deposit typically is going to be credited against the cap claim made by the landlord, and any excess security deposit will go back and be refunded to the estate. Third-party guarantees and pledges are considered separate under a lease, and in essence, there's only going to be a cap on the estate liability, not actual damages suffered by the landlord. In essence, the landlord can seek the difference between the amount owed under the lease and the amount recovered from the estate. The claim filed by the guarantor is basically going to be limited to the same extent that the landlord's claim is against the debtor. I think on letters of credit, it's important to talk about the independence principle, which in essence is that the issuer's obligation is independent from the estate. And a letter of credit has a couple different advantages. Being issued from a bank, it's going to be superior to a third-party guarantee because you're going to avoid the credit risk related to the third-party guarantor. And the letter of credit draw is typically not considered property of the estate. Instead, the proceeds are viewed as kind of similar to a third-party guarantee, which is not credited against the landlord's allowed cap claim. I think lastly on that, it's just important to keep in mind that really the cap is not limiting the landlord's ability to recover under the letter of credit. It's just really reducing the amount the landlord can claim against the estate. And some courts have acknowledged letters of credit to security deposits and reduced the landlord's lease rejection claim. Other courts have analogized letters of credit with third-party guarantees and have not reduced the landlord lease rejection claim. So I will turn it over to Greg, who's going to address some of those specific holdings under letters of credit and guarantees and security deposits.
Sure. Thanks, Rob. And we should be up at slide 41 now, I believe. And I'll be brief here because we are running a little short on time, and there's other material we'd like to cover. But the main issue with letters of credit as a third-party source of recovery for a landlord under a lease that's rejected is that, I think as Rob previewed, the recovery against the letter of credit itself is not capped, but the recovery that the landlord obtains from that third-party source is going to reduce the amount of the landlord's capped claim as against the debtor's bankruptcy estate. That's the vast majority of courts are so held. I think there's one or two cases out there that may be outliers on that point, but that's where most courts end up. The last point on this topic that I would just touch on briefly is on slide 43, and it speaks to what is the role of 502b6 when the debtor is not the tenant but is guaranteed the obligation under a lease for a non-debtor party. And again, here I think that the outcome is pretty straightforward. Most courts have said 502b6 still applies to cap the landlord claim, that there's nothing on the face of the statute that precludes its application, and that the claim will be limited for the landlord's recovery as against the estate. I think unless anyone else has anything to add, that concludes our coverage of 502b6 and related matters. The next topic, which is on my to-do list, is deals with the interaction between 363F and 365H. There wasn't a whole lot going on in this area for a long time, but there has been some recent activity on this topic in the last few years, culminating most recently with a decision by the Ninth Circuit in a case known as Spanish Peaks 2. At a high level, what we're talking about here is 365H, which is a provision in the code that operates for the benefit of tenants of a debtor lessor, and says in substance that if the debtor rejects your lease, you have the option, excuse me, to remain on the premises for the duration of the lease term, as long as you continue to pay rent. The flip side of this is 363F, which of course, often comes into play in business bankruptcy cases and others, as a means of selling assets free and clear of all liens, claims, and interests. And what a number of courts have confronted over the years is, is this right conferred by another provision of the bankruptcy code under 365H an interest that you can strip out through 363F sale? And not surprisingly, the courts haven't agreed on how to deal with this. Until relatively recently, there seemed to be a majority approach, although one that was really adopted mostly by bankruptcy courts, and one might argue that they have the burden of trying to be practical in these situations and fair to everybody, and perhaps that has some motivation in some of the outcomes of their decisions. But these courts in general have said that there does appear to be a conflict between these two code provisions, and that since 365H is the more specific of the two, that in a situation where there's an attempt to sell free and clear of that 365H right, the non-debtor tenant's 365H right should prevail. The one outlier case for many years on this was the Seventh Circuit decision in Qualtech Steel, which had taken a much more textual view of the statute, and had sort of drilled down on the specific language and said that the provisions really weren't in conflict. Until recently, that was the only really circuit-level decision speaking to this issue through a close examination. Recently, then, in the Seventh Circuit, or excuse me, the Ninth Circuit, we got Spanish Peaks Holdings 2, and then George will briefly talk about a Third Circuit decision that talks about the operation of 365H that came out of the Rebel bankruptcy. But in Spanish Peaks 2, this is the sort of by now infamous, high-end ski resort that was created in Big Sky, Montana, and has produced probably dozens of decisions by now, because the former owners have either been the target targets of lots of litigation or have created lots of litigation in that case. It's now known, I think, as the Yellowstone Club. But the upshot of this was that in the process of creating this resort, the debtor had entered into 2 commercial real estate leases, one for restaurant space with an entity that was an insider, in effect, by the name of Pinnacle, and another one was another commercial real estate lease to another entity by the name of Opticon. Lo and behold, 2008 or so, debtors default with their lenders on a $375 million loan. They get pushed into bankruptcy. Case initially is filed in Delaware, gets promptly transferred back to Montana. And very quickly, the lenders working with the Chapter 7 trustee in the case, initiate or encourage at least a 363 sale process for the assets of the bankruptcy estate. A typical sort of 2-part motion is teed up with bid procedures followed by a sale hearing. The insiders who control Pinnacle and Opticom object at the bid procedures hearing. The bankruptcy court initially declines to deal with the issue and approves sale procedures that, essentially somewhat ambiguously say, well, the 365H rights are what they are and they're preserved for the time being. There's an auction, banks credit bid, they win, or successful bidders based on the credit bid, and it gets teed up to a sale hearing, and the landlords renew their objections at the sale hearing. They do not, however, and this will become important, explicitly seek adequate protection at this point in time. So they object to the sale on the basis that, you can't sell free and clear my 365H rights. The bankruptcy court conducts a 2-day trial on this, and it makes several findings that are ultimately sort of important to how this plays out. One, it notes that they hadn't actually been operating on the premises for several years. 2, it finds that the leases were not at arm's length and are far below fair market value for the rent that was being charged. 3, at least in Opticom's case, the lease wasn't recorded. 4th, they were, again, effectively under control of insiders. 5th, there were a number of bona fide disputes as to the terms of the leases and their enforceability. 6th, you've got there was no non-disturbance arrangement with the senior lenders who held the mortgage on the property, and therefore nothing that stood in the way of foreclosure. And then finally, there was no evidence that the landlords would suffer any particularized economic harm from the rejection. So this is the record that existed when this case goes up on appeal. I believe it was directly appealed to the Ninth Circuit, and the Ninth Circuit essentially follows the Qualitex deal approach here, and it makes an important point about this particular case that'll distinguish it from another case we'll talk about briefly, which is that there had not been any formal rejection of these leases or deemed rejection of these leases at the time of the sale. And so in the Ninth Circuit's words, where there is a sale but no rejection, or a rejection but no sale, there's no conflict between Section 363F and 365H. And while there were these inchoate rights under 365H, essentially the Ninth Circuit seemed to be saying there's not an interest in the 363F sense that is that it, that is that issue here that might demand adequate protection, or that might not be an interest of a nature that you couldn't sell free and clear of. It just hadn't evolved to that point, or you might say from the standpoint of the tenant, that they had not been given the opportunity to invoke it because the leases hadn't been rejected. And just to pause and note that this is, in practical application, this does suggest some possibility for manipulation by debtors and trustees of the process if people are not attuned to this issue. It may mean that in a situation like this, a tenant would need to show up early in the case and move to compel assumption rejection of its lease, where there is a possibility of a sale process like this as a means of at least putting 365H into play and protecting itself. So, and the court, was very clear that it was not deciding the situation where there was an actual rejection and left open that it might approach things differently. It probably could have stopped there, but it didn't. It then went on to say that, in any event, these guys were dopey and didn't ask for adequate protection until after this case was up here on appeal, so they've effectively waived it as an appeal issue. And so I don't really need to get there, but the court did make a fairly sweeping statement to the effect that the broad definition of adequate protection makes it a powerful check on potential abuses of free and clear sales. So it seemed, at least in concept, to leave that door wide open. But then, as it continues, the court kind of closes it again, and it says, I'm going to take, and again, the court probably didn't need to get here, but it did, a fairly broad view of the powers to sell free and clear under 363F. Given the facts as found by the bankruptcy court here, and while I have no briefing on this from any of the parties really, I think that a hypothetical foreclosure scenario is one that theoretically could have arisen here with this particular lease and the lack of recording and so on, and therefore 363F1 would have been hypothetically satisfied. It then observes that in the court's view, 365H in this situation doesn't create rights. It's not intended to put any tenant of a landlord debtor in a better position. It's simply intended to preserve the status quo. And that's where they leave it. It does refer, in the course of this opinion, to an earlier decision that came out of the Southern District of New York in 2014, Dishy and Sons versus Bay Condos. This particular opinion did have to deal with the direct conflict issue because there had been a deemed rejection of the lease in Dishy, and so there was really no getting around how do we interpret these two provisions. But all of that said, I think it's still, found that the provisions were not on their face inconsistent with one another. That we're still dealing with a situation where 365H goes no further than protecting the tenant's rights as they existed under non-bankruptcy law, not creating any rights above and beyond that. And so up to this point, the court takes a fairly consistent approach with Qualitex Steel, and that would be followed later by Spanish Peaks too. Where things start to diverge then is the court talks about how it's going to apply 363F and 363E when it comes to selling free and clear and adequate protection. And the court takes a quite narrow view of what it means to sell free and clear of an interest under 363F. And it says in substance that, it interprets the statute as referring to the debtor's ability to sell free, to extinguish a junior interest. And so the scenario of the hypothetical mortgagee foreclosing is not one that is contemplated by the statute. The court then moves on and considers 363F5, which is the provision that says you can sell free and clear where a money satisfaction would suffice. And again, it opts for a very narrow interpretation of what that means, and says it only applies in a situation where the trustee, as the owner of the property, not a third party, not a mortgagee, could compel a money satisfaction of that interest, and concludes that that's not been satisfied here. And then the last sort of nail in the coffin here of any attempt to sell free and clear under this case's facts is the court's view of what is appropriate adequate protection. And, it's not as clear as it could be, but I think it could, you could read the language very broadly to say that the court is saying that, retention of possession is generally going to be required for the tenant to be adequately protected in a situation like this. I guess I personally don't know that it went quite that far, because there was, the court did make a significant point to note that there was no evidence that there was any other form of adequate protection that would allow the tenant to receive the juvenile equivalent of what it had in its leasehold interest. So this might have been a failure of the evidentiary record to have been created for the court's review, as opposed to the court really intending to make a very broad pronouncement. Before I hand it over to George, I guess the last observation I would make about this is I know this is a fairly sort of discrete issue that we don't all see a whole lot, but we do also need to think about this in other contexts outside of 365H, and particularly we've seen these same arguments made from time to time under 365N related to selling free and clear of intellectual property interests, as unsettled as this law is, I think that has the opportunity to create a lot of uncertainty there as well. With that, I'll pass the baton to George.
Sure.
Talk about Revel.
So I will talk about Revel for about 30 seconds because I want to definitely hand it over to Rob to talk about some of the takeaways here. So very briefly, and I know we're almost out of time, 365H, for those of you who haven't encountered it yet, it is the provision where the lessor is the debtor. And you have a debtor landlord who wants to reject the lease, and the non-debtor tenant, lessees, have rights, right? So they have a right to remain in possession, and they have other ancillary rights. So they'll be able to recover some cash, for example, if they have to get out and so on. So there are rights that these tenants have. You can't just throw them out under 365H. However, under 363F4, if you have a bona fide dispute, right, you might have the authority to sell free and clear. And eventually the Third Circuit, I won't go through the evolution of the case from the bankruptcy court to the circuit, but the Third Circuit held there has to be a bona fide dispute. You can't just, call out 363F and rely on F4 by claiming dispute to trump, in order to trump 365H. There has to be a dispute. So the Third Circuit basically said that the debtor's reliance on a provision in the lease that made it appear that the tenant, the non-debtor tenant, was basically just getting a percent. There was a percentage lease provision rather than a fixed rent provision. The fact that there was a percentage lease provision didn't suddenly create something that wasn't a tenancy. It wasn't a partnership, and certainly it was borderline fanciful that there was any type of real dispute here. So the Third Circuit said, no, not so fast. You can't just rely on 363F4 to sell free and clear. There is no tension between these two statutory provisions of 365H and 363F4. So sad, too bad. Debtor, you can't just get out of 365H. So that, in a nutshell, a very small nutshell, is Revel. And now to the considerations. And Rob, if you want to run through your list here, because I think there are a couple of important points that we should cover before we wrap.
Sure, thanks. I just wanted to touch on the business perspectives, and I just wanted to highlight for a second the kind of the broader retail apocalypse that's causing record number of store closings, and really, in turn, an increase in lease rejections and related issues in the retail bankruptcies. The demise of bricks and mortar, it's more than just the rise of e-commerce, i.e. the Amazon effect. There are a lot of other contributing factors, which include the previous overexpansion of stores, as well as shifts in demographics, discretionary spending, and shopping patterns. But looking back at the Amazon impact just for a second, it is a major force that's causing this retail trend to evolve. If you just take Toys R Us, they rose to prominence, by being a category killer. They were the big box retailer that created the retail apocalypse of their time, killing all the mom and pop toy shops, and now Amazon's the largest toy seller and is doing it to them. And as Greg had mentioned earlier, pre-petition planning and filings is the way to go now. Store closings this year, for example, 400 each for retailers like Gymboree, Route 21, Payless stores. And this year we're really on track to significantly outpace even closures during the financial crisis in 2008, which just tells us this is a transformational change. Bricks and mortar retail is in a secular decline. And another interesting point is, since 2006, approximately 50% of the retailers that have filed ultimately liquidated. The other half were mostly sold, as Greg had mentioned, through 363 sales or reorganized. And the rate is actually 5 times higher than non-retailers. And the question is, why do retailers liquidate? And there's 3 main reasons for this as it relates to the bankruptcy process. And the first is it can really be difficult to pass the best interest test. Oftentimes, liquidation value of inventory, typically 100% of cost, oftentimes sets a high bar, which makes it really difficult for a reorganization to be better than a liquidation for each class of creditors. Second, 2005 change in the bankruptcy code, which was the introduction of 503B9, in which goods sold in the 20 days prior to filing were given administrative priority and must be paid in cash on a plan's effective date for a retailer to emerge as a going concern, has killed a lot of retailers. Like Circuit City had 350 million of those claims, and that doomed it from a liquidity perspective. And I think third and the most relevant to this webinar, and more important than the first two, is the 2005 change to Section 365D4, which was mentioned by George earlier. It limited the period for rejecting leases to a maximum of 210 days absent landlord consent. This modification to the code dramatically accelerated the time frame for retail restructurings. In essence, a retailer only had a few months to sell or reorganize before being forced to liquidate. Practically speaking, this shortened runway works like this. The lenders will reverse engineer when a retailer must decide to reorganize or liquidate. And given it takes up to 90 days to complete a GOB sale, and the lenders are going to want all the lease decisions to be made long before the 210-day deadline, lenders usually require through DIP milestones that a retailer decide to reorganize or liquidate in less than 120 days. This only gives the debtor about 4 months to decide if a lease will be rejected. Thus, pre-petition planning in terms of assumption of rejection is of critical importance here. And I guess with that, I was going to address all of the individual questions, but I think we're probably out of time. I'm happy to entertain questions if anyone has them on the specific questions, but I would just say that the determination of whether a lease is important to a successful reorganization, and the performance of performing a store closing analysis and rationalization will be important to understand the financial implications, by lease, by landlord, and by region. And I guess with that, I'll hand it back to Greg, who I think was going to finish up with lease rejection procedures, but I'm happy, if anyone has questions later, to address any of these specific questions.
Yeah, thank you, Rob. I think on lease rejection procedures, we have some material on the slides on that cover those, and it's pretty self-explanatory. So unless there are specific questions that folks have, we'll leave it at that, because I know we're probably keeping many of you from lunch.
Okay, thanks, Greg. I don't think there are any other questions. So we appreciate all of your time and effort that you put into this webinar, and thank you for sharing all of your insights on this topic. And thank you also to ABI's Real Estate Committee for hosting the webinar today. If you're not a member of the committee but are interested in joining, membership is free to you if you're an ABI member, and you can sign up for this or any other committee at committees.abi.org. Of course, if you're not yet an ABI member and are interested in joining, you can do so at our website at abi.org. For those of you needing CLE credit for this program, our CLE coordinator will send an email to you in about a week or so with directions on how to obtain your CLE credit. And thank you again for attending our ABI Live webinar. Look for our next webinar on our website at abi.org. Have a great day.
Thank you, everyone. Bye-bye.
Thank you, everyone.